with your capacity as a detective captain, maybe perhaps you can explain to the rest of the members of the council regarding search warrants and how we're going to how we get into people's homes and all that, and what the process is. Because I think some folks here, some of my colleagues here are understanding we're just going to go into people's homes. At least that's what I'm gathering, and perhaps you can explain to us all that what the process is in order for us to gain entry to search warrant.
Regardless of whatever program that the Danbury Police Department would be involved in, we're still guided by Connecticut law and federal law, but primarily Connecticut law. And we're Danbury police officers of the state of Connecticut first. So in order to effect a search, we need a search warrant. The search warrant has to go through, in this case, if we're ICE-trained officers, to go through either our court here in Danbury or through ICE, through one of the U.S. attorneys. But it would follow those guidelines. So there's no way that a raid on a house could be effected without a search warrant, unless there was exigent circumstances, a hostage situation, somebody's in there heavily armed, things like that, and they're all covered under constitutional law. So being part of this program doesn't take the Danbury Police Department or those officers out of those guidelines that they have to follow under state and federal law.
Thank you. Regarding the first part of my question, we have had incidents where we've detained individuals for a fair amount of time trying to ascertain their status. Isn't that correct, Captain?
Yes, that is. And it can work both ways. As the chief pointed out before, we might have to detain somebody an inordinate amount of time to find out what their status is. On the other hand, we've released people only to find out their status afterwards, and that there were not only ICE warrants for them, but warrants from other jurisdictions within the United States.
That had to do with a lack of ability to identify the individuals?
Under the present informal agreement that we have, yes.
So obviously, more tools, more resources are going to lead to specifically these tools, these resources will most likely lead to more effective police work in incidents as you just explained.
Exactly. And being more efficient would also help the citizens of the city of Danbury from being either held up a little too long, or the Danbury Police Department releasing somebody into the populace who shouldn't have been released.
Thank you,
Mr. Sott.
Thank you, Mr. Chairman. To Captain Weston and or Corporation Counsel, I've heard some of the same concerns, and in a little bit more detail, I want to enumerate them regarding the protections of individuals who would be otherwise arrested or detained through this program. And somebody correct me if I'm wrong, and I don't mean to be facetious about this response, and all due respect to some people who have raised these issues, that there is nothing in this program that vitiates, abrogates, gets rid of over 50 years of constitutional protections that go back to the Warren Court with regard to 4th, 5th, 6th Amendment rights, 14th Amendment rights to the federal government, as well as 1983 Civil Rights Act protections, or Section 1983 protections. Am I accurate in saying that? I don't mean to be sort of rhetorical here, but I've heard a lot of disinformation. Someone want to just say yes or no?
You're exactly right.
I know in my own experience that going for and applying for warrants is sometimes an arduous process, and that arrests done without warrants are done, you see it all the time. You run in after somebody with a weapon into a house. You find someone throttling their spouse. You don't get a warrant, you arrest them. Now, after that, they are arraigned and are afforded all the protections that the court has upheld, both through the circuits and the Supreme Court. So some people have said that these types of programs are going to eliminate those rights, or what are we going to put in place to keep them, to protect those rights? to protect it. It's in place. Now, I have a follow-up question then, too, with the representative from ICE, please, or someone else who can answer. I've heard indirectly and anecdotally that both Homeland Security and even FBI and other federal agencies, when individual agencies, departments, or personnel enter into MOUs and receive training, if they then violate provisions of the MOU, there's disciplinary procedures or penalties that can be meted out. Either they're kicked out of the program or something else. Can you explain if Homeland Security or ICE has the ability to withdraw from an MOU or pull back resources or information because of abuse by a department or an individual potentially, aside from the discipline they'd get from their own department and potential lawsuits? Please.
I can certainly imagine that because this program is supervised by Immigration and Customs Enforcement, it comes under the aegis of our own internal review process and our own internal misconduct investigators. The Office of Professional Responsibility, OPR, would investigate our officers if there was an allegation that somehow we violated the rights of an alien, and I would imagine that the same people would investigate if someone was operating under color of law of 287G under our supervision. And certainly the Undersecretary has the right to terminate any agency who was not living up to the responsibilities of the Memorandum of Agreement.
If I may follow up through the chair, is the ICE, as a subsidiary of Homeland Security, subject to inspections and review by the Inspector General's office?
That's correct, sir.
Would the Inspector General's office review or audit potentially those types of programs either on their own or based on complaints that trickle up through the pipeline?
I have not yet personally seen that type of an audit, but I understand that is their responsibility.
Thank you, Mr. Miller.
Mr. Perkins for the second time.
Thank you, Mr. Chair. Through you, Chief Baker. Just to follow up on my original line of questioning concerning, let's just call it criminal element. I asked earlier what type of statistics are kept on the different types of arrests of illegal immigrants. You told me none, but the packet that you sent out concerning the field survey asks specific questions concerning that type of activity. I just want you to help me with the disconnect.
I guess we'd have to answer unknown because we don't really know.
What about the database? Through the chair. Can the database help identify these people? Because that was one of the important aspects of the program. So I'm just trying to figure out how the survey questions can be blank.
Mr. Perkins, could you please pause 1 second where you have to change the tape? Okay, Mr. Perkins, you may proceed. Thank you.
I'm just trying to figure out how there can be no data on arrests, but there is a field survey sheet that asks certain questions like, you know, how many aliens per month will be identified, percentage of jail population foreign-born, average monthly booking of foreign-born nationals. Those are all questions here on stuff that you gave us in a packet. So I know that a lot of stuff that the police department does is data-driven, so it would seem to me that these things would need to be answered.
We'll do the best we can with that survey, but we do not keep information on persons arrested or crimes committed by immigration status. And if you look in our capital improvement budget for the last 3 years, including the 08-09 submission, we're asking for new software to better make our decisions with data, but we don't keep that data, and we don't have the methods to keep that data right now.
I would just like to say something. Although I do support various types of immigration reform, I'm having serious reservations with this process. Councilman Lotella pointed out some ambiguity. I just looked at some inconsistencies. I would like to see this whole agreement before us, before we even
vote on anything. I'd like to move to amend this motion to require the final MOU to be presented to the council prior to its approval. Amend the initial motion to have the MOU come back before the council for approval. Is that correct, Mr. Perkins? That's right. Under discussion on the amendment only. Mrs. Stanley?
Thank you, Mr. President. On the motion, I don't think it's necessary for our council to micromanage the chief of police and the duties. I think it's something that we're not trained in, and it's a job that the chief of police can handle.
Folks, I can understand where you're coming from on that, but please, we'd like to get through this, and interruptions, we just can't have them. So if we please refrain from clapping. Mr. Seabury?
Thank you, Mr. President. I would like to echo Councilman Stanley's sentiment. My feeling on the whole thing is that we hired the chief and look at him as basically the expert on these types of issues. If we can't rely on his opinion, then I think that we're doing a severe injustice for something. I want to rely on the chief to make decisions on this. Therefore, I will be voting against this amendment.
Mr. Curran?
Yes, I'll be voting against this too. We've had this since October. We're not that ignorant that we all have computers. We've all been looking at this. We've read, I've gotten more emails sent to me. I've got more letters sent to me, more phone calls sent to me. The thing I think I'm most upset about is, last time I checked, ICE belonged to our government, not some other government. And all you hear is bad things about ICE. And they're sworn officers of our country, not a foreign country. And they take a hell of a beating around here. But I just want to say thanks for the great job you do. And I'll be voting against this amendment too.
Thank you, Mr. President. I would just like to say that every day, us as a council, we vote on resolutions, and that's where very often we authorize the mayor and his designee, the chief of police or whoever, to continue with the work of the council on our behalf because they are the experts. And because of that reason, I will also be voting against the amendment.
Thank you, Mr. President. This is no reflection on the chief or the police department's ability. I think it's most of the questions I've received and the emails I've received. People have genuine concerns as to how it's going to affect our community. You know, you look around and we see immigrants on work sites throughout our community. They are involved in all aspects of the economy of this community. We're very, very concerned. Who's manning our restaurants? Who's sitting behind the checkout counters at Target and Costco's and you name it. So there's a serious concern that the people have asked their representatives, us sitting on the Common Council, to vet this out and try to get as much information as possible. And at this point, I need some clarification myself in the memorandum of understanding. In the packet that was given to us, the information indicates that the MOU has to be reached prior to the governor or the senior political entity or the head of the local agency beforehand. And yet, in the opinion of the Corporation Council, it says that the memorandum of understanding has to be done prior to entering into an agreement with the ICE. So which one of these is correct? Can someone answer that question? This one conflicts with that one.
Mr. Levy, I have an answer to that question too. Not two, but we conducted a careful review trying to understand, the cart and horse kind of thing. I understood that people had some concerns over entering into an arrangement prior to a final document being signed. The interesting part about the documentation is that we have some local law, and I relayed some of that to you before, that is fairly conservative and fairly careful, that the Common Council, the legislative body, needs to authorize the mayor to enter into arrangements with the federal government or enter into contracts generally. That's one angle of this. The other angle, interestingly, in the documentation, Mr. Levy, is that nowhere in the literature is it so specific that it says the chief of police can't even enter into this on his own authority. In fact, the Immigration and Naturalization Act, as I mentioned before, implies that, and because many of these memoranda have been executed by police authorities, we decided to take a more conservative approach, is to come to the Common Council at the Council's request and at the Mayor's request, explain the program, provide the memorandum of understanding that we were concerned about how much will the Council be comfortable with knowing. And we express to you, and we're comfortable, I'm comfortable, that although the exception to the rule sometimes is that you ask for a document to be returned to you, this is not one of those cases, only because the vetting that's been done prior to this proposal is fairly significant, even though there may be a couple of questions that folks have brought up that seem to be unanswered. But the process of coming to the end of this agreement is really at hand. There are only two clauses in this agreement that have any, if you will, uncertainty at all. And even those uncertainties are eliminated by the chief and the mayor providing to the council those components of the ICE Access program that they want. And by the way, those components happen to be in page 2, paragraph 4. So that leaves one other paragraph in the agreement, and that paragraph is paragraph 5 on page 3, which is what are the functions that you'd like to adopt. You've heard the functions, and there's been some question and answer about that. Aside from that, ICE doesn't require that an MOU be returned to the council later on. It leaves it up to the genuine discretion of the legislative body, as well as the best procedures that you have. And your procedures in the past and policy has been, in terms of resolutions, in terms of grants, in terms of even the more recent open space bond proposal that you put out to the public, is that you many times leave it to the discretion and the wise discretion of those you've tasked and appointed to carry through on areas where they have the expertise. So, and this is one of those cases. The police chief has access to information, has contacts with ICE, has contacts with others, is perfectly capable of taking this proposed motion to enter into arrangement to conclusion without difficulty. So what you're left with is really any uncertainties that we're here and happy to answer to get to that point. I don't, just to get back to the basic question, I didn't see any specific clause in any of the documentation that required a return of the MAU to the legislative body.
Well, I would be glad to supply you with that information. But I too have a lot of faith in our experts in the field. That's why they're employed, because they're considered to be experts. And I think our police department does a great job. But I also know that there's a lot of misinformation out there, and clarity is necessary. But if I understood what you said the police chief could probably enter into this agreement on an administrative basis without common council approval?
There's a possibility of that, yes, based on language.
I see. Okay, thank you very much. I would support my colleague's recommendation if this amendment fails, and that is to partner with a task force of local community leaders that would keep an eye on what is happening in our community to try to build the gap that may exist now or in the future between the multicultural society we live in. Thank you. Ladies and gentlemen, please.
Thank you, Mr. President.
Just a point of parliamentary inquiry, just a clarification on the motion, the amendment. The amendment is to require that the document come back to the council, but it also allows the negotiation to proceed as proposed in the ordinance. Is that correct to the maker of the motion? Just, it's on the record. Is that correct?
Mr. Perkins? Frank?
Thank you.
Mr. O'Connell?
Yeah, I mean, just to clarify, we would move forward with the petition while simultaneously awaiting for further review of the MOU. Yeah, we've heard a couple of things tonight that are interesting. One thing that we've heard is that we really don't need to be sitting here to do this, that this could be handled purely administratively, or at least a case can be made. We've also heard that that case might be a little shaky, so that they thought it would be in the best interest of the community if they asked the council to deal with this. And I have to say, with all due respect to Corporation Council Administration, if you're going to ask the council to deal with it, you have to deal with the council. We've heard a lot of things tonight, and I think one of the most reasonable things we have heard is if you're going to sign a contract, and it is the most controversial contract in the history of this generation in Danbury, it makes some sense to read the contract before you sign it. We've also heard that there's only a couple of things in there that could possibly be, a variable, so it really doesn't make any difference. And if it doesn't make any difference, let's just look at the contract before we sign it. This is not contrary to what we've heard tonight, some amusement for the council to put pins in a butterfly and stare under glass. It's not to get down to the detail and drill into the police department. This is a very simple thing. We are on the precipice of entering into a historic agreement, and we were doing it to some extent with our eyes not fully open. There's a motion on the floor to amend that so that we can open our eyes a little bit. I, for one, will be voting for the amendment, and I will not be voting for the motion should that amendment fail. I represent a good portion of the 6th Ward in Danbury. They have told me on both sides, the people that are for this and the people that are against this, they have been talking to me for 2 weeks, and I can't talk to the proponents about their success if the motion passes without being able to tell them in detail what it is exactly that they've passed, and I will not be able to talk to the opponents without telling them in detail what it is that they've lost. So I think this is a very, very small but very important process that we as a body should go to and go through, since we have been asked to decide this. We don't have to. We can wash our hands of it, table it, and the administration can go on its way and do this administratively, and good luck to them. But if they're going to ask us to do this, let's take a good look at it. Let's move it forward. Let's get the training, and let us get a really good look at that MOU. Thank you.
On this side, Mr. Calandrino?
Thank you, Mr. Chairman. I can't speak for the folks in the 6th Ward, but I can certainly speak for the voters in the 3rd Ward. Since 2003, when I first ran for election, a brand new candidate, on the first day, as I knocked on the first door, the prospective voter asked me why we weren't doing anything about immigration, and then slammed the door in my face. When I ran for re-election in 2005, immigration and taxes, real estate taxes, were the main concerns. And when I ran in November, immigration again came up along with open spaces and some concerns about real estate taxes. They were the buzzwords. Well, I'm going to vote against this amendment, and I intend to listen to the voters in the third ward, and I intend to vote for this initiative with ICE. Thank you.
Calandrino? Hey, folks, please. Anyone else on this side? Mr. Cheney?
Thank you. Again, through the chair. To Corporation Counsel, regarding the MOU, what is the length of time that it would take to negotiate such an agreement? Maybe the ICE representative could also, what's the time frame we're talking here?
Councilman Cheney's, hard to say, except that it depends, number one, on the time frame and how busy ICE is in terms of other applicants, for example, in terms of how long it would take them to set up the process for Danbury to address some of the issues. So it's uncertain how much time it would take. I've understood it might take a period of a few months for processing.
We're not talking like 18 months or 2 years. We're talking a relative 1 to 2 months.
More likely on the short side, yes.
Again, also to follow up on something, I think it's important to us as a council that we do take a look at this MOU in good detail. Because the last time this council, which I wasn't on the council at the time, took a look at an agreement, it wound up biting us in the behind because we didn't look at it carefully enough as something that was considered to be broad. I think a lot of us here in the last 2 years were kind of fighting over the terms in the contract, so to speak. So will it hurt this council if we do take a look at this? I mean, we spent 2.5 hours tonight discussing it. We spent the last meeting discussing it. What's it going to hurt if we take one quick look at it to make sure that is what we expect it to be? I think we have 21 on here. We all expect it to be one way. But how do we know for sure unless we take a look at it again before it's finalized? I think a lot of us here will probably approve this MOU, but I think we need to see it before we approve something, because otherwise it's like signing a blank check. And I would like to see it before it gets approved too. So I think we should take a look at it, because I don't think it's going to hurt us if we do take a look at it. You know, it will hurt us if we don't. So I would urge at least just to think about it, you know, that we should at least take one quick look at this before we sign it.
Thank you, Mr. Cheney. Anyone else? Okay, on the amendment to the motion to, pardon me? Mr. Shire requesting a roll call vote. On the motion to amend the main motion to bring the MOU back, to proceed with entering into the MOU, bringing it back to the council for approval. I'll try your minds on a roll call vote. Would the clerk please call the roll?
McMahon? No. Majorset? No. Johnson?
No.
Montero?
No.
Valentino? No. Perkins?
Yes.
Visconti?
Yes.
Cheney?
Yes.
Esposito?
Yes.
Sadi?
Yes.
Cabo?
No.
Seabury?
No.
Costello?
Yes.
Diggs? Yes. Mitchell? No. Marcanti?
No.
Curran? No. Knapp?
No.
Levy?
Yes.
Riley?
Yes.
Campbell?
We have 12 noes, 9 yeses. The motion fails. Back to the main motion. Back to the main motion. Mr. Seabury.
Thank you, Mr. President. I'd like to call the question now, on the main motion.
Motion's been made to call the question.
A roll call, sir?
All those in favor of calling the question signify by saying aye.
Aye.
Opposed? Would- Okay, we'll have a roll call vote, please. Will the clerk please call the roll?
McMahon? Yes. Makachek? Johnson?
Yes.
Bombetta?
Yes.
Palladino?
Yes.
Perkins?
No.
Visconti?
No.
Cheney?
No.
Esposito?
No.
Dottie?
No.
Cabo?
Yes?
Seabury?
Yes.
Botello?
No.
Diggs? Rachel? Yes. Marcanti?
Yes.
Kern?
Yes.
Knapp?
Yes.
Levy?
Yes.
Riley?
Yes.
Stanley?
14 yeses, 7 noes to call the question. Now try your minds on the main motion. Do a roll call vote as well, since we're in that process? Why not? Will the clerk please call the roll on the original motion, which is to recommend to the council that the city proceeds into entering into an agreement with ICE, the federal government.
McMahon? Yes. Makachek? Yes. Johnson?
Yes.
Bombetta? Yes. Palladino?
Yes.
Perkins?
No.
Visconti?
Yes.
Cheney?
Yes.
Esposito?
Yes.
Dottie?
Yes.
Cabo?
Yes?
Seabury?
Yes.
Botello?
No.
Diggs? Yes. Rachel? Yes. Marcanti?
Yes.
Kern?
Yes.
Knapp?
Yes.
Levy?
Yes.
Riley?
Yes.
Stanley?
We have 19 yeses. We have 19 yeses and 2 noes. The motion passes. Seeing no further business, that can probably...
Chairman, I make a motion and we adjourn.
Thank you, Mr. All those in favor, thank you. Thank you very much.
I want to know where that big black cop is that escorted us out the last time.
That's called scary cop.
He was big, right?
You're still on.